So I just want to check in with you before we start. I'm having some challenges. Okay, there we go. Sorry. Okay. Okay, so you can see my screen or not yet? Oh my goodness.
Is it the PowerPoint presentation you're wanting to bring up?
Okay, no, I want to bring up our slides, or do you have it? Sorry, I'm not too familiar with your system.
There we go.
Okay, so are the slides showing on your side?
They should be here. There we go. They're showing on our side now.
Okay, great. So I can go ahead.
Yes, so you can just click at the bottom where it says 1 of 26. Then when you want to move on to the next one, just click on the slide.
Okay, great. Perfect. Thanks so much. Thanks for the intro and thanks for the opportunity. It's always a privilege for us to be part of the training sessions. So today we're talking about the Voetstoots clause, which I think we all can probably write a book on. It's a very important clause. It plays an important role, into managing a sale transaction and concluding a sale transaction to start off with. So yeah, let's start. So the term Voetstoots, it's such a weird word. It dates back from the Roman Dutch law principles that we had, where it literally says to shove with the foot. So it's to say that whatever you're buying, you are buying it as it is in the condition that it is, and there's no guarantees on the seller's part, that there, might not be any issues, or he's not guaranteeing that the item is perfect. And the reason this is such an important clause is because in our common law, there's actually an implied guarantee that what you are selling is fit for purpose, that there are no known defects. So you can see how that is quite a heavy commercial burden to put on the everyday homeowner when they sell a property. And that's why we have the Voetstoots clause. That's quite an important part, to just say that the seller can't guarantee that the property is 100% perfect. So we need to really always ensure that it's, in our sale agreements. And it's such a silly thing to say, but I can promise you that I recently had an example where my estate agent accidentally used the wrong template. He used the templates that they normally use for the developers. Developers don't have the same protections that normal sellers do, because they're developers, they're governed by the Consumer Protection Act. And so accidentally in that sale agreement, there wasn't a Voetstoots clause. And we had to bring it in, which was so difficult and was so awkward, because now we had to go back to our buyer and say, we're bringing in this clause. And our buyer's first question was, why is something wrong with the property? Which isn't the case. It's just a normal retail transfer sale, and the agent forgot to use the right template, which has that clause in there. Okay, so I've mentioned to you, it's really important that we have this clause. It contracts out of the common law principle, and it really does cover both latent and patent defects. I'm going to chat to you a bit about what is latent and what is patent, and how do we differentiate, and what's the different obligations on the sellers and agents when it comes to disclosure. So a seller can only in limited instances be held liable for defect if there's a Voetstoots clause. So again, that comes down to what is patent and what is latent. I'm going to chat to you about that, but it really focuses on knowledge. Did the seller know the roof was leaking? Did the seller know that there aren't building plans? Those types of questions. And if a seller knew but did not disclose it, then whether the Voetstoots clause is in your contract or not, your seller will still be liable for any repairs or correcting those defects. So knowledge plays an important part, and there's absolutely no excuse for malicious or fraudulent misrepresentations, regardless of the nature of your contract or any clauses in there. Okay, so am I going too quickly? Is everybody still okay at the pace? yeah, please, if there's questions, you can just type them in the chat box.
All good, Madeleine. I think what we'll do is just ask anybody at the end if they've got questions, and then you can answer them then. That'd be great.
Perfect. Thanks so much. Okay. So latent and patent defects, it's important that we do differentiate between the two and that we are able to explain to clients what the difference is. Latent is anything that's not easily seeable. It's not something that's easily visible. So if your buyer is at a property, looking at a property, carrying out a reasonable inspection, the buyer would not know there's a problem. An example would be a roof that was leaking and it was recently fixed and paint over, or it wasn't fixed and paint over. That also happens. It's something like skew boundary lines, no building plans, zoning issues. It's something that's not easily ascertainable or reasonably ascertainable, and you wouldn't know there's an issue unless you specifically told there's an issue. Patent defects are patent to the eye, they're easily seeable, and that includes something like mold in a cupboard. If you open the cupboard, you can see there's mold. So that is a patent defect. So that's the difference. So when it comes to the Voetstoots clause, the Voetstoots clause protects your seller against liability in both aspects, but there's an exception. So patent defects are 100% secure. So if a seller says, look, I'm selling this property as it is with all issues, you can see the window is broken, you can see there's water damage, I don't have building plans, you're buying it as is, then that's it. The buck stops there. Then the seller cannot be held liable for any of those patent issues. Latent is a bit different. Latent, again, comes down to the seller's knowledge. So if there's something that the seller knows about, he has an obligation to disclose that. If the seller keeps quiet about it or fails to even consider the fact, then the seller will get into trouble, even if there's a Voetstoots clause. So those are quite important. At the very end, I'm going to share with you a few examples that we've dealt with. Or maybe I can just share with you one now. It's a transfer that we did in the West Coast, a lovely home situated right by the beach. It's a beautiful property which has a granny flat at the back. So naturally it was a quick sell because everybody wants a property which has an extra flat, especially when it's by the sea. So it quickly sold, and our buyer asked the agent, are there building plans for the granny flat? And she asked the seller, and the seller said, yes, of course. We just built the boundary walls, so we know for a fact anything with the municipality is up to date. We went through that process. It's all done. The buyer also, or the seller also completed on the disclosure form that there are building plans. But I'm going to chat to you in detail about the disclosure forms. So what happened as we were preparing our transfer, our buyer just said, just a reminder, I would like to see copies of the building plans. And we got the building plans and we sent it through. And as it turned out, the granny flat was actually approved as a recreational area to have a gym and a jacuzzi and a spa. It wasn't approved for granny flat for somebody to live there. And that was a huge, huge debacle. It actually took us a year to just find a solution and to tell the seller and to convince them, look, you gave an undertaking, you said everything was right, you put it in the contract, you gave full acknowledgement that there is building plans. So whether the Voetstoots clause is in there or not, that's a guarantee that you gave. And so the seller had to pay 40,000 Rand to get building plans sorted out. So it was a huge zoning issue. It was really quite technical. So you can see how latent defect, something like that, is quite important to disclose everything that you know that the seller told you about the property. Okay, so that's one example. So moving along to what the Voetstoots clause entails. So the general idea is that, no house is perfect. There is no property on the market, doesn't matter how expensive it is, whether it's brand new, it really doesn't matter. No house is 101% perfect. It might be the most beautiful property ever, which is great, but there's always something that could potentially be seen as a defect. And so the Voetstoots clause is really there where the seller says, I'm buying the property as you see it. What you see is what you get, whether it's latent and patent. Mr. Buyer, you need to do your own inspections. I'm selling, this is what I'm selling, and you taking it. So that is the general gist of it. But I always explain to both my buyer and the seller that the Voetstoots really also protects your buyer, because your buyer and your seller, in the sense that it's almost as if what you're selling is frozen in time. So what the buyer sees is what he or she gets. And there's a duty on the seller to maintain the property, but there's also no expectation on the buyer that the seller would do upgrades or would fix anything unless specified. So it really actually is a good way of just managing expectations on both ends. So, and it really avoids a lot of comebacks or any underlying issues that might arise after the fact. So, and although you and I might think Voetstoots is such an obvious clause, I do want to tell you that we often get buyers that ask us, Madeleine, what is Voetstoots? What does it mean? So it's really important that you guys please just spend a second or two when you sign up your offers to explain that to the clients. Okay, coming back to patent and latent defects. Patent defects, like we said, that's your broken window. That's the crack in the wall that everybody can see, or the bubbling wall with water dam. It's visibly. The courts have a rule that they say, buyer beware, caveat emptor, which really says, Mr. or Mrs. Buyer, when you inspect a property or you view a property, you need to make sure that you are properly inspecting this property, know what you are buying, because if there's a Voetstoots clause in the contract, your seller is completely protected. Okay, so when it comes to patents, defects, we covered. We know it's the seller has, or the buyer has an obligation to also do his part, so our seller is covered. But what about the latent defects? Latent defects, as I mentioned, is quite something else. In general, yes, the Voetstoots clause does protect our seller, and our seller is not required to fix something that he doesn't know about. But if he does know about it, then disclosure really is key. And there's a court case that I'm going to share with you later on where the court says, sellers, you can't tell half of the truth. You need to be open about something, and you really also need to put a bit of thought in as to what you need to disclose and convey to your agents and your buyers. So it's not simply a matter of relying on the Voetstoots clause. But we do have a new development in our law. As you know, as of 1 February, we have the Property Practitioners Act, which regulates the estate agent industry and property sales. So what the Act has basically brought in Section 67 is that you cannot accept a mandate. Now remember, this is a verbal or a written mandate. You cannot start marketing a property if you don't have a signed disclosure form by your seller. Guys, this is so important. It's at mandate stage, so it's at the beginning of the relationship. It's not at offer stage. So I know practically this is a big challenge because sometimes sellers, especially with the open mandates, don't want to sign a disclosure form. They don't want to sign anything. They don't want to give a speaker. We know that's a challenge in the practice. But the Act says when you start marketing a property, you need to have your disclosure form in place. And the best advice that I could have for you is not to complete the disclosure form unless the client is sitting with you and you're going through question by question. Otherwise, the best would be for your seller to complete the form, or for somebody who has actual knowledge of the property condition, like a rental agent or managing agent, or somebody that's actually involved with the property, to complete that form. What if you do a deal and you don't have a disclosure form? Well, that is where you are exposing yourself, because the Act says if you don't have your form completed, or you don't attach it to your mandate and you don't attach it to your offer, the agreement will be interpreted as if there are no defects. So that would mean your seller would have to fix every single thing. So if there is a crack in a wall or a kitchen cupboard which is going off the hinges, anything and everything which is not 100% perfect, your seller will have to fix. Okay, so this has a huge impact on our industry. And, I really want to urge you guys, whether you're selling residential or commercial, agricultural, whether you're selling or leasing, please, this form is really a must when you engage with a client or you take on any mandates and listings. So what happens if you don't? So as an agent, if you fail to secure your disclosure form to have it completed and signed by your seller, you will be constituting or entering into a minor offense. So that would actually be something that could get you in trouble with the board, and also a fine may be imposed not exceeding 15,000 Rand. So guys, that is a huge fine. Please, it's really worth it to just try and get your sellers to sign the form, complete and sign the form. But over and above this fine, you could actually be held liable if a party suffers damages because you did not inform them that this form was necessary, or because you did not urge them to complete it. Okay, so it has a huge impact on the transaction, and it is huge exposure on your side. There is one caveat, there's one exception. A buyer will only be in the position to come knocking on your door if the buyer has inspected the property, and if it is a latent defect that, had it been on the form, it would have made an impact on his decision. Okay, so the buyers remain, under the obligation to know what they are buying. But guys, please, we don't want you to get in trouble. Please make sure that your disclosure form is part of your client onboarding package. Okay. What about the Voetstoots clause and your mandate? How are you protected as estate agents with the Voetstoots clause in your contract? Now, the law on this is quite technical, because as agents, you are the seller's agent. So you are an extension of the seller, right? So you can actually only go on your instructions. You can only go on what your seller tells you. But the Voetstoots clause is a clause that regulates the relationship between your buyer and your seller. So there is a court case where there's some protection where the court says an agent can't help if a seller doesn't tell him. So there is protections in that sense, because you cannot be held liable for something that you did not know about. But you can be liable for not fulfilling your legal duties. And your legal duty in terms of the Property Practitioner Act is making sure your seller completes that disclosure form, or gives the information needed to complete it and signs that form. And then there's also somebody that would be able to sign on his behalf if that's necessary. An example would again be your rental agent, or somebody managing the property for him or her. So yeah, I can't stress the importance of that form enough. Okay, so case law. We had a very interesting court case. It was a 2017 Supreme Court of Appeal case. So the Supreme Court of Appeal is basically our highest form of authority. So it's good to have cases like this, because it applies to all provinces and it really gives certainty as to how we should be dealing with the law. So in this matter, Ferraris bought a property from Oudendal, and it comes down to building plans not being in place. But what happened was Ferraris went to view the property, right? Saw the property, loved the property. But at the back of the property, there was an outbuilding. And the outbuilding was a pool room, as well as there was a jacuzzi in the building, and there was also a little room that they used for laundry. And at the viewing, the agent didn't have the keys for the pool room. The agent asked the seller countless times, can we have the keys? We're having this viewing. So the agent didn't have the keys. And the agent asked the seller, but why are you not giving us the keys? Is there something we should know about? And the seller said, no. I can't remember. There was a whole issue about the keys. But the long and the short was, at the time of the viewing, the buyer saw the entire property apart from this outbuilding. And the buyer asked the agent, is there something that I should know about regarding this outbuilding? And the agent said, no, the seller told me everything is hunky-dory. no problems. Great. So Ferrara puts in an offer, buys the property, moves into the property. So what actually happened on the day that they moved in, the staircase to the second floor, to the first floor, actually, as they were moving up the stairs with furniture, actually came loose and fell next to the buyer's 6-year-old child. Okay, luckily nobody was injured. So that was a major alarm. They bought this house and the staircase fell down. So what else is wrong, right? They finally got the keys for the outbuilding, and when they opened up the door, they saw that the entire ceiling of the pool room was damp and had water damage. At the back where there was the laundry room was actually constructed over a sewer line with a big manhole in the middle. It's something you actually can't believe, but that's the truth. The pool was leaking, the jacuzzi wasn't working, every single thing went wrong regarding that outbuilding. So it was a huge issue. So now you have a buyer with occupation, right? We're waiting for transfer. So the transaction was obviously cancelled by the attorneys. The buyer phoned her bank and her bank stopped the transaction because obviously you've got a building built over a sewage line without building plans. So it's a huge thing. So the bank didn't want to fund the transaction. And it was a whole fight. The buyer said, Mr. Seller, this is your fault. I'm not moving. So it ended up being an eviction. So it was a really messy matter. The seller said, look, I'm innocent. I didn't build the outbuilding. What you're seeing here is how I bought the property. I was happy with it, so that is how it is. Obviously claiming that, the whole issue with the building plans was the previous owner's issue. But it ended up being that the previous owners had obtained building plans, but the building plans indicated that the outbuilding was supposed to be used as a storage room, and the sewage line had to be moved before the construction was supposed to be commenced. So that was obviously not that. So the approvals were not in place. And at the end, the court considered the matter, and the court said that the buyers remain under the obligation to properly inspect a property. Now, we're not asking buyers to be technicians, we're not asking them to be professionals, but they are supposed to carry out a reasonable inspection. And the court said, buyer, why did you not ask for the keys or hold off with the offer until you had the keys to look what's going on in the pool room? So that was something that the court were quite strict about. But the court also said, Mr. Seller, you can't fraudulently not disclose any issues. So at the end of the day, please remember that this case was decided before the Property Practitioners Act. The court said, had the buyer gone through the length of insisting on keys and carrying out a reasonable inspection of the pool room, they would have seen the manhole, they would have seen the water damage through the ceiling, they would have seen what was going on in that property. And by deciding to put in an offer without the keys, they took a risk. And the court therefore held them to at the end of the day, it came back to damages. They had to vacate the property and they had to compensate the seller. Okay, so the Voetstoots clause lived up to its reputation. It protected the seller because the defects that there were patent, and the buyer could have seen them had the buyer taken precautions and insisted on viewing the property. Then we have another court case, which is also quite interesting. This one, it's Solier to Alice. Solier sold actually a wooden house to Ennis, and the house was actually based against a slope. So to me, I'm seeing alarm bells, but that's the fact of this case. So we've got this wooden house against a hill slope, and we've got the Voetstoots clause in the contract saying, buyers, you're buying this house as is. So soon after taking transfer, the buyers started with their renovations. And in doing the renovations, they realized that there were quite a few huge structural issues that weren't disclosed to them. So again, this is a 2011 case, so it's long before the Property Practitioners Act. And as they started their renovations, they found out there were some of the original flooring had been cut out in the kitchen. They also saw that a very interesting technique was used to level out the floors, that the wooden floors was actually topped with the cement or was screeped, and then wall-to-wall carpets was installed to level out the floors. They actually saw that the poles supporting the wooden structure were busy caving in, and that the whole property was subsiding. There were ceilings loose. It was really quite the situation, and the property was in a dire condition. What did the buyers say? Look, I wouldn't have bought if I knew. If you told me that this is what you did to stable the poles, if you told me this is what you did to level out the floor, this would have affected my decision to buy, or I would have paid less. I would have made a lesser offer. That's what the buyer said. What did the seller say? I didn't know. I know there's an issue with the poles. And they also actually said that what they did to level out the floors, and they cut out of pieces of the wooden flooring, was aesthetic and cosmetic, and they don't regard it as defects at all. And the court really went to town with them. The court really had a look at all the relevant case law and basically said, a seller can't tell a half-truth. A seller needs to really consider the matter and needs to really consider, if I was buying the property, what would I know? Could this be relevant to a potential buyer? And by not considering the significance of these huge structural and material aspects of the property, they were basically electing not to fully disclose all relevant and material attributes regarding the property. And the court did not excuse the seller and saw it as fraudulent and malicious misrepresentation. So I think that is a fair decision in this regard, because a seller should have regard to what could be material and what couldn't be material. We recently had a matter where it's quite interesting. We did a transfer and the seller was involved with the homeowners association, and in fact he was the inspector on the estate who did all the inspections to make sure that building plans are in place and nobody's doing something they're not allowed to do. Very interestingly enough, turns out that seller didn't have building plans. There were a few contraventions of the homeowners rules, and all he said was he didn't know. And that's not excusable. If we look at the case law that we have, sellers should really also be reasonable and consider all the relevant facts. And in our situation, if you are the person in control of approving construction at the estate, then you should really know, and not having knowledge is no excuse. Before I end off, I just would like to touch on something, and that is inspections and viewings of properties. I'm certain you all are familiar with the terms of your property disclosure report, which is obviously the prescribed report that's available on the board's website. You're welcome to brand it. That's fully acceptable. You're welcome to add information. You're just not allowed to take any info out or delete anything. So those forms are really important. So I would like to invite you to just have a read through them. At the top, you'll see there's a disclaimer. It really actually nicely explains that although the seller is not including any guarantees in the disclosure form, the seller is aware that the buyer is using the information on the disclosure form to make an informed decision regarding the sale, the amount that he's offering. So that's a fair statement, and it really helps the parties to just realize the importance of the form. The form also mentions that a buyer is entitled to have a professional inspection done, in which event the buyer will have to foot the bill for that inspection. But this needs to be pointed out to the buyer. The buyer needs to know that, look, before putting in this offer, I'm actually allowed to have this inspection done. It is a bit difficult to take in an offer subject to the inspection, but that's, of course, something that can be done. And we are, of course, there to help you draft any specific clauses in your contract if those inspections are to be carried out after the offer is put in. But please keep in mind, professional inspections aren't mandatory. The buyer must just be aware of the right to have the inspection done at the buyer's cost, of course. Okay. So that's it from my side. I don't know if you have any questions. I think I spoke so quickly. But yeah, if you have any questions, then I'm happy to help.
Thank you so much, Madeleine. I think it's always nice to use case studies as examples. It kind of makes it more real. If anyone has any questions for Madeleine, please feel free to type it in the chat.
So if you think of something later on and you really just want to pop me an email or WhatsApp or reach out to us via Michelle, please do. We are there for you. So please, it's not a once-off session. So we're there for you guys. So if you have a question, please reach out to us. We're there for you.
Thank you so much, Madeleine, and thank you for stepping in for Hein. We really do appreciate your input.
Anytime. It was such a pleasure. Good luck to everybody, and we'll see you soon.
Absolutely. Thank you.
Bye.
Bye. Okay.